Hi, I'm Debbie Moraes. Welcome. This is Legal Matters, the program designed to address the critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk on a wide variety of topics from credit issues and bankruptcy to divorce, family law, personal injuries, and more. In our last few segments, we've been discussing personal injury and most specifically medical malpractice. And not surprisingly, there are many more issues that we're going to be discussing today about malpractice. And we're going to begin today with the question which came in from our viewers. To answer us is David Bazar from Audette, Bazar, Cordeiro Grasso law firm. So, relative to medical malpractice, one of the viewers writes, I had a procedure, a surgery, 3 or 4 years ago. No complaints at the time, but it wasn't quite right. Am I entitled to pursue this with a lawyer right now? It really is a problem, I think, now, David.
All right. The question you're asking really pertains to a statute of limitations. And in a medical malpractice case, generally, the statute of limitations would be 3 years. But there's a caveat to that. And the caveat is it's 3 years from the day you knew or should have known that there was malpractice. So if at the time of the surgery you're not sure that there was a problem and it developed 6 months, say, afterwards, and now you're 2.5 to 3 years out, you still may have a window of opportunity to bring a case. So that person should consult with a lawyer so they can determine whether or not the statute of limitations has run or has not run and whether or not they're barred from bringing the case at this time.
What's reasonable? I mean, there are times when a patient may say, gee, this doesn't quite feel right. That could be normal. It may not be normal. I imagine that most doctors aren't going to be quick to say, well, gee, I think there's a problem with the procedure. They might more likely say, well, it will take time, which is understandable. How do you really know when there's something that could be suspicious?
That's what that discovery rule period is all about, because, as you say, there's always a recovery time. From a surgery that went fine, there's a recovery time. From one that didn't go so well, that may not be malpractice, as we discussed last time, there's a recovery period. And if there was malpractice, you may not know it until after a period of time has gone by. So if you haven't recovered as you might have expected to, or if things are worse than they were before and don't get better, that period of time would be a reasonable discovery period to determine whether or not there was a problem from the surgery and whether or not that was malpractice or not. What you have to bear in mind, as we spoke about before, not all procedures that don't go well are malpractice.
Right.
So once you've
That's
determined...
an important distinction.
Exactly. But once you've determined that you're not getting better and that it may be worse and there might have been something that could be malpractice, that's going to start your period of time to investigate it and have an attorney look into whether or not a claim could be made.
Good point. Thank you. So, another aspect of personal injury law, we decided that we would discuss product liability today. And I guess there are lots of theories about what's wrong with product liability, and I think most consumers are aware of things like baby seats that don't work, or the FDA, the pharmaceuticals like Crestors, the Vioxxes, and then sometimes just the goo that comes out of the tube that's supposed to fix every wrinkle that I ever thought of having. What is product liability about? What's the scope of that about, David?
Right. Product liability in general is when someone is injured as a result of a defective product. And there's a number of theories of law which you can sue on that's developed over time. We've talked about negligence in general, auto accidents we talked about, right. And when someone negligently rear-ends you and causes you an injury. Well, a negligence theory can be brought to a product's liability. The manufacturer, for instance, may have been negligent in manufacturing a product, the product's defective, and you're injured as a result of that negligence. That's one theory that you can bring to a product's liability case. Second theory, it comes from contracts. And for instance, when you buy an automobile, the car comes with a warranty. And there's 2 different types of warranties you can have. One would be an express warranty, where the dealer, the manufacturer say to you, this car is going to be a very good car with no defects for 3 years, 30,000 miles, 5 years, 50,000 miles, or if you've got a Hyundai, 10 years, 100,000 miles. Those are express warranties that are made, and that's an actual contract made between the party who buys the car and the manufacturer. The law also has implied warranties. When you buy a product, especially a new product, there's a warranty called an implied warranty of merchantability. And what that means is, generally, the product is an ordinary product fit for the purpose that you bought it for. So if it's a car, you would expect that you'd be able to drive down the road and the steering mechanism wouldn't fall out and cause you to be injured, or the airbag wouldn't suddenly deploy and cause injuries. Those are three different types of theories that you can bring to the same set of facts and the same injury.
Would it also include something that might be another part that was maybe not an originally manufactured part? Say that you're buying a used car. You might expect that that car would be drivable off the lot, but suddenly the radio doesn't work the next day. Is that part of a product liability? Is that part of the liability from the dealership? Or
well,
how does that work?
If the radio's not working, theoretically, you wouldn't have been injured. The car might not work the way you expected it to, and that would be a warranty made that the components of the car will work, the radio will work. That would be just a breach of an express warranty. You'd bring it back in, and the dealer would fix it under the warranty. You'd
have a reasonable right to expect that.
Right, but when we talk about products liability in the context that we began the show with, we're talking about products that are unreasonably dangerous that cause an injury.
How do you really define what's dangerous? When you buy a product, whether you're consuming it or whatever, you expect that you won't get sick from it.
Right.
You expect that it won't break. You use it as you think you're supposed to use it. Where does defect come in? How does that really play out?
It's a good question because it brings us to the third theory of liability. I don't think I discussed that yet, which would be strict liability. And what's developed over time is if a manufacturer makes a product that is defective, and that defect is something that is unreasonably dangerous, and it leaves the hands of the manufacturer and gets to the consumer in the condition that it left in, it wasn't changed or altered by somebody else, then that consumer ultimately can sue anybody in the chain of commerce who touched the product. So for instance, let's talk about the automobile, if you will. Ford, let's say, manufactures a Pinto, and the Pinto goes to a Ford dealer who sells it to the consumer. And the consumer's driving and it got rear-ended, and remember, those were the vehicles that the gas tank was a little too far back or some such thing, and they could blow up on a rear-end accident. So the manufacturer, Ford, could be liable. Perhaps the manufacturer of the gas tank could have been liable because you talked about original manufactured equipment. They could be liable, and the dealer could be liable. So you can get everybody in the chain of commerce for liability, and the liability is based on that theory, strict liability, because it was an unreasonably dangerous product that got to the consumer unaltered by anybody else and caused an injury to the consumer or their, in that case, passenger, as a result of the negligent design or product liability.
Actually, you bring up another point, which, as I understand it, there's the issue about the manufacturer, but there's an issue about design. Well, maybe the product is manufactured to specification, but that actual specification, when it was designed, was a problem. So how do you decide when someone's car blew up? Am I going after that dealership? You're saying everyone in the chain, and there could be many, but how far back does it go? Who decides that? Is that you? Is that, how does that work?
It would be the lawyers as they look at it. Now again, I told you there were three theories of liability. The negligent theory can be also many-pronged. It could be negligent manufacture, it could be negligent design, it could be a failure to warn, because perhaps something is designed and manufactured correctly, but there's a defect to it that isn't so obvious, a latent type of defect, that if a warning was given, somebody wouldn't use it in a certain way that might not be so obvious. The thing that comes to my mind actually is a ladder. If you notice now, most ladders have a warning that the top rung is not a step.
Do not use.
Do not use. Well, it's designed the way it's designed, which is probably correct for a ladder. And it could have been manufactured correctly, but without that warning, people might not know that you're not supposed to go to that top step, and it's dangerous. Therefore, the first lawyer who got that case and saw it said,